When two people sign a marriage certificate in England and Wales, they lock themselves into a legal structure that is remarkably difficult to dismantle. The primary architecture governing that structure and its termination is the Matrimonial Causes Act 1973. This timeline illustrates a strict temporal limitation. Under Section 3, a practitioner cannot file for divorce during the first 365 days of marriage. It's an absolute bar. Historically, Parliament designed this gap to force a mandatory cooling-off period, preventing over-hasty decisions following a quick marriage. But this creates a severe dilemma in practice. If a client is trapped in a hostile domestic situation or facing a massive financial drain during month 4, what legal advice do you give when they simply cannot legally divorce? The one-year bar creates a procedural vacuum. Standard dissolution is legally impossible, which means we have to find an alternative statutory remedy. That procedural vacuum isn't limited to newlyweds. You will also encounter clients who have passed the one-year mark but hold strict religious or moral objections to dissolving a marriage entirely. For these exact scenarios, the statute provides a specialized tool, judicial separation, under Section 17 of the Act. Judicial separation is often misunderstood as a mere stepping stone to divorce. It is actually a discrete, permanent legal state, provided the parties choose to leave it in place. To use it effectively, we have to analyze exactly how Section 17 mechanically operates and where its hidden financial traps lie compared to standard divorce. When full marital dissolution is legally barred or personally unacceptable to the client, Section 17 becomes an indispensable surgical option. The Divorce, Dissolution, and Separation Act 2020 removed the need to prove archaic, fault-based facts like adultery or unreasonable behavior. To initiate a standard divorce today under Section 1, the applicant provides a simple statement asserting that the marriage has irretrievably broken down. Compare that with the filing requirement for judicial separation under Section 17. Judicial separation does not require an assertion of irretrievable breakdown. The applicant only states that they seek a judicial separation. That minor semantic difference allows Section 17 applications to cleanly bypass the one-year absolute bar. Administratively, applications for both pathways are submitted through the same digital HMTCS portal and can be made jointly or by a sole applicant. The procedural timeline, including conditional orders and minimum wait periods, generally mirrors the divorce process to ensure due process. The paperwork looks nearly identical, but the Section 17 pathway bypasses the strict timeline of divorce by demanding only a desire to separate rather than a declaration of final ruin. Legally, a marriage is best understood as a bundle of rights and duties rather than a single monolithic status. Under Section 18(1) of the Act, an order of judicial separation specifically terminates the legal obligation of the spouses to live together. Unlike a divorce, which destroys the central marriage node entirely, a judicial separation preserves the underlying legal status. The immediate practical consequence of preserving that central node is that neither party is legally permitted to remarry. However, severing the duty to cohabit protects both parties. If one spouse leaves the family home, they cannot face allegations of desertion. Judicial separation is a highly specific legal maneuver. It neutralizes the physical expectations of marriage while leaving its legal architecture intact. Decoupling their physical lives inevitably requires decoupling their assets, which brings us to the crucial financial reality of separation. Securing a judicial separation unlocks the family court's jurisdiction to make most financial remedy orders found under Part 2 of the Matrimonial Causes Act. The court can mandate lump sum orders, property adjustment orders to transfer the family home, and periodical payments. Courts can also grant protective measures, like non-molestation or occupation orders, exactly as they would in a divorce. But there is a major statutory exception that can trap an inexperienced practitioner. As this matrix compares the two pathways, both allow for property restructuring and maintenance. But when it comes to pensions, courts cannot make pension-sharing orders in judicial separation proceedings. This limitation is devastating for clients whose primary wealth is tied up in a spouse's pension. It forces a strategic reassessment of whether Section 17 is financially viable. While Section 17 opens the door to property restructuring, The absolute ban on pension sharing makes it an incomplete financial remedy for high-asset older couples. There is one final hidden consequence of Section 17 regarding death and inheritance. Normally, under the rules of intestacy, a surviving spouse inherits a significant protected portion of an estate, but Section 18(2) applies a brutal mechanic. If a judicial separation is in effect, the surviving spouse entirely loses their automatic succession rights on intestacy. The law applies a strict legal fiction, treating the surviving spouse as if they had already died for the purposes of distributing the estate. Practitioners must advise clients undergoing judicial separation to urgently update their wills to reflect this statutory reality. Section 17 actively rewrites the default protections of marriage, turning intestacy into a major liability. How does a practitioner identify a candidate for Section 17 in the consultation room? Consider the trapped early client, a couple married for only 4 months where severe financial abuse is occurring, necessitating immediate court intervention over assets. Section 17 allows the lawyer to secure property adjustment orders without waiting out the 1-year absolute bar. Next is the faith-bound client. Their religious convictions forbid divorce, but they require state authority to enforce child maintenance and sever cohabitation. Section 17 provides the safety of strict legal boundaries while respecting their theological limitations. Finally, the pension protector client. Section 17 is the wrong choice here. If a client needs a pension share, they must wait and file for full divorce. Mastering Section 17 requires knowing exactly who it protects and exactly who it leaves vulnerable. Judicial separation operates as an archaic tool modernized for precise tactical deployment. It severs the daily duties of cohabitation and restructures finances while leaving the skeletal legal structure of the marriage intact. For a modern family practitioner, understanding the nuanced differences between Section 1 and Section 17 is what elevates basic legal processing into elite strategic counsel.